Criminal solicitation of a minor is a serious charge in Texas, and it often comes as a shock to those accused. Unlike many other criminal offenses, it does not require any physical action, only a request, command, or attempt to persuade a minor to engage in certain conduct can be enough to lead to a felony charge. The law is designed to be strict, and law enforcement takes an aggressive approach when these accusations arise, particularly when they involve violent crimes, sexual offenses, or human trafficking. Under Texas law, a minor is defined as someone under 17 years old. If a person solicits a minor to commit a felony offense, they can be charged under Texas Penal Code section 15.031, and the crime is complete at the moment the solicitation occurs. It does not matter if the minor actually commits the felony or even intends to. Simply making the request is enough to warrant criminal prosecution. Because Texas has some of the toughest laws in the country regarding crimes against children, these charges carry severe legal consequences. Depending on the nature of the alleged solicitation, a conviction can lead to years in prison, steep fines, and even mandatory sex offender registration if the case involves certain offenses. But not every allegation is cut and dry. There are legal defenses that can challenge the evidence and the intent behind the charges. A unique feature of Texas law provides an extra layer of protection for defendants accused of this crime. According to the Texas Penal Code, a person cannot be convicted solely based on the uncorroborated testimony of the minor involved. This means the state must provide additional evidence that strongly supports both the claim that solicitation occurred and that the accused intended for the minor to act on it. Corroborating evidence could be things like text messages, recorded conversations, witness testimony, or any physical evidence that connects the accused to the solicitation. While this legal safeguard is significant, it does not mean these cases are easy to beat. The state is often well prepared, and prosecutors will pursue any evidence they can to support their case. Even if the accused claims they were joking, that the minor did not act on the request, or that they never intended for the minor to actually commit the crime, none of these defenses automatically shield them from liability under Texas law. The severity of the penalties depends on the felony that was allegedly solicited. Texas classifies the offense one category lower than the crime the minor was asked to commit. For example, if someone solicits a minor to commit a first-degree felony, such as aggravated robbery, the solicitation itself becomes a second-degree felony. That means a possible prison sentence of 2 to 20 years and fines of up to $10,000. If the underlying felony is second degree, such as indecency with a child, the solicitation is a third-degree felony, which carries 2 to 10 years in prison. However, if the solicited offense is a capital crime, like capital murder or child trafficking, the charge automatically rises to a first-degree felony, meaning a potential sentence of up to 99 years. This charge is often confused with another Texas offense, online solicitation of a minor. While the two may seem similar, they are legally distinct. Criminal solicitation of a minor applies to any form of communication, whether in person, by phone, or online, where the intent is to persuade a minor to commit a felony. Online solicitation of a minor, however, specifically involves the use of electronic communication to engage in sexual conversation or arrange an in-person meeting for illegal purposes. Both offenses are serious, but they fall under different sections of Texas law and carry different penalties. A conviction for criminal solicitation of a minor can have lifelong consequences, including mandatory registration as a sex offender if the solicitation involves certain offenses. This includes crimes such as sexual assault, indecency with a child, or human trafficking. Registering as a sex offender can limit housing, employment opportunities, and even daily freedoms. That is why fighting these charges aggressively from the start is crucial. If you or a loved one has been accused of criminal solicitation of a minor, do not wait to seek legal help. These are complex cases that require an experienced defense attorney who understands how to challenge the prosecution's claims, scrutinize the evidence, and protect your rights. The attorneys at Varghese Summersett have handled high-stakes criminal cases and understand what it takes to build a strong defense. We will work tirelessly to fight for the best possible outcome. If you are in need of legal assistance, contact Varghese Summersett at 817-203-2220. We're easy to find if you search for us on Google, but you can also find us at versustexas.com.